been some time since we've talked about Kyle Rittenhouse, but we have a little bit of an update because there's a new motion that was filed by the Kenosha prosecutor, Thomas Binger, asking for the court to allow new evidence to come in, evidence about other acts. And so we're going to take a look at what these other acts are, and we want to really unravel why does the prosecutor want to get this stuff into court in the first place. Kyle Rittenhouse, if you recall, of course, this was the shooting that took place back in Kenosha, Wisconsin, some time ago last year in the aftermath of the George Floyd killing. Kyle Rittenhouse, young man, I think he was 17 at the time, ended up shooting and killing several people after he was being, in my opinion, chased down the street. When we did our analysis back on this, back right after it happened, I was firmly convinced that this was a very clean-cut case of self-defense, and I am still of that mindset. I'm further entrenched in that mindset and kind of still surprised this is going on. But in life, as we know, things often go on for many different reasons. In the criminal justice system, as of late, those reasons have largely been political. And so this is going to continue on because Kyle Rittenhouse has become a symbol of something bigger than the underlying incident. Just like Derek Chauvin did, just like Breonna Taylor became, just like George Floyd became, and the list goes on. So now we're smack dab once again in the middle of what many people are calling a political prosecution. Let's figure out what's happening here. The Daily Mail is reporting that a new motion seeks evidence of Kyle Rittenhouse's past violence. They want that admitted into court. So in Wisconsin, prosecutors filed a motion saying that he had a previous encounter in Kenosha before he shot two men. The state's motion was filed Thursday. We're going to take a look at it. Before we get into it, let me show you what's happening at the court docket. So as we talked about last time, on May 21st, 2021, we had a new attorney join the game. So Kyle Rittenhouse got attorney Corey Chifarsi, Chiarifi. Okay, you got it. We got attorney Corey who joined the team. And shortly thereafter, on that same day, we had a final pretrial conference, right? And a final pretrial conference generally isn't the final pretrial conference. So we say this a lot in law. No, this is the final conference. It isn't. Right? We always say it, and it always gets sort of continued out. And so this was supposed to be the final one, but it's not going to be. We're going to have additional hearings before the trial takes place, as we are going to see shortly. But let's figure out what happened back on May. It says that ADA Thomas Binger, which is the prosecutor, and Jason Zapp, another prosecutor, they showed up. The defendant was there with his attorneys, now Mark Richard and Corey Chifarsi, which along with Kyle Rittenhouse. We had some other attorneys also show up. Everybody reported that they are working on discovery. Discovery is the case file, right? That's the police report, officer's notes, body cameras, witness statements, all that stuff. The government then, they requested that the court set a deadline for the filing of motions, right? This is back on May 21st. We're going to see now, we've got some motions being filed. The state's motion now was filed on July 1st. So we're going to get there. So back in May, they say, give us some deadlines. Defense has no objection. Motions are set to be filed by 7/1. Okay, which was on July 1. We'll notice that the state got some motions filed in. We'll see what else came in on the next slide. So we also know that the defense, so Rittenhouse and his team, they have to disclose their expert witnesses by August 1. So that's coming up soon as well. Also, the filing of any expert report. Okay, parties have their jury questionnaires also by August 1. So we're staying on track. We're going to be moving towards a trial. And a motion hearing is then scheduled for September 17th. The jury selection is going to happen on November 1st. The length of the trial is going to take 2 weeks. So a lot of activity, a lot of scheduling stuff was done at that final pretrial. Then we had the video conferencing. Of course, that was for that. A receipt of something was filed, probably this motion. And then we have the state's motion now to admit the other acts evidence. Other acts evidence. What is other acts? Well, we're going to take a look. Filed by ADA Thomas Binger, right? Thomas Binger is that obnoxious prosecutor that we've been talking about. So let's see what else is happening here. We noticed, right, that there was a deadline for everything to be filed by 7/1, July 1. So guess what happened on July 1? A bunch of stuff was filed, right? We saw previously that the government filed their motion. They want to get other evidence in. We're going to see what the government wants. It's going to be stuff that makes Kyle Rittenhouse look bad, naturally. So we're going to take a look at that. But some other things were filed. Let's see what else. We have motions in limine that were also filed on July 1, filed by Kyle's team, Richards and Shifarisi. And then we have motions to admit evidence filed by Attorney Richards. We have motion to dismiss count 6 also filed. We also have a defendant's demand for specific discovery also filed, right? And so we have receipts for some payments and another receipt here. Now, I will tell you this. I do not have these documents. I tried to find these documents. I do not have them. I did submit a request over to the court clerk over there from Kenosha County, the circuit court. Very, very nice woman named Sarah. And she has responded, and she's going to send us an invoice, and we're going to purchase those documents, hopefully. So that happened today. I've been usually able to find the Rittenhouse documents. For some reason, these are not available. So I'm going to see if I can get those through public records, but they're just not out there. So if I can get them and post them, I'll do that. But I don't have them yet. So we'll see. Apparently they want us to send them a check. And so I got to send them a check. Like, I think, we got to go buy a check. Okay. Anyways, we'll get the documents, but we are able to get a look at the state's other acts motion, right? I got this document over from a supporter who is a member over at Andrew Branca's site, Legal Insurrection. So go check them out. Everybody's gathering these documents and sort of sharing them. So go support them. But this is where the document came from. Kyle Rittenhouse, the state's motion to admit other acts evidence. Let's take a look. This was filed on July 1st with the clerk of the circuit court, Kenosha County. It is 9 pages. Let's go through it relatively quickly. Filed against Kyle Rittenhouse, right? Date of birth, 2003. State of Wisconsin as the plaintiff versus Kyle Rittenhouse. Take notice, the document says, that the prosecutors, Thomas Binger and Zaff, they're moving the court to admit this for admission of other acts evidence. What else? Specifically, we want evidence that the defendant assaulted a female in Kenosha on June 1st. So that one piece of evidence of an assault. And we also want, if you're a prosecutor, that he's associated with the Proud Boys organization, which is a violently racist organization, which, again, I don't know how that's true when the one of the Proud Boys is not a white person. So I don't really know how that works, but apparently it does. So let's go into this other acts motion. It says the defendant is charged with offenses in the first degree, reckless homicide, dangerous weapon, all of that. They all occurred on August 25th, 2020. Right? August 25th. They're going to say there was another assault that happened on June 1st, so a couple months earlier. Wisconsin courts, they give us a 3-pronged test as to whether or not to admit this evidence. Number 1, is it offered for a permissible purpose? Number 2, is it relevant? And number 3, is the probative value outweighed by the risk of unfair prejudice? So a couple things, right? We're talking about Kyle Rittenhouse. He's being charged with crimes for shooting people. So what the hell does this prosecutor want to talk about a prior act from June? What does he want to talk about Proud Boys for? Does that have anything to do at all with what Kyle did that particular night? That night. We're going to see. The prosecutor thinks so. And so they're going to go through this test and they're going to say, well, look, here's what the test in Wisconsin says. Pretty easy. It's got to be admissible for a permissible purpose. So we got to have a good reason to get it in. It needs to be relevant, right? It's got to be somewhat related. So it's like if the allegation was that Kyle stole a candy bar, how is that relevant to a shooting? Whereas an assault, which might be an act of violence, might be relevant. Okay, so it's a little bit different. And also we're talking about Rule 403, which is the probative value of the evidence outweighing the prejudicial effect. Very important rule. If you're going to law school, you're gonna have this rule beaten into your head, especially in criminal law. If you want to get evidence admitted into court, the question is, essentially, is it going to do more harm than good? Is it going to answer a question that we really need answered? Is the probative value of this information, is it going to be probative? Is it going to give us some information that we need? Yes. Okay, that's great. But is it prejudicial? Is it harmful? Is that information too harmful that it overweighs the probative value, right? And so we had a lot of these conversations in the Chauvin trial when the defense was trying to get in the co-defendant, the passenger, can't remember his name off the top of my head, but they wanted to get his testimony in, right? Because allegedly he was selling pills and he had given George Floyd drugs and all sorts of that stuff. The government said, nope, that is way too prejudicial. It's not probative enough. It doesn't give us it doesn't answer any questions about whether or not George Floyd was killed by Derek Chauvin. So most of that evidence got kept out. And I think it wasn't really kept out under Rule 403 as much as it was under the right against self-incrimination. That other defendant invoked those rights, but you get the point. If it is too harmful, they'll keep it out, even if it is valuable. It's got to be more probative. You put these two things on a scale, the benefit of the evidence versus the harm of the evidence. If it's more beneficial than harmful, we're going to let the evidence in, as long as it's also permissible under the rules of evidence and it's relevant. Okay, so that's some legal stuff. The burden of establishing those two prongs, of course, is on the person seeking to admit it, and then it shifts to the opposing party to show the third prong. So they're showing you sort of what the value, or how the evidence process works. They go through, they give us some statutes here. So several admissible purposes. So proof of motive, opportunity, or intent, preparation, plan, knowledge, and those types of things. So they're going to want to say, well, that this stuff proves Kyle Rittenhouse's motive. The fact that he is a part of the Proud Boys, well, he's got a motive, right? Or he's got a plan. Or he's got intent to shoot people because he's a Proud Boy, or because he's an assaulter, or something like that, right? So for example, context of the crime, to provide a complete explanation of the case. So you can show somebody sort of operates in conformity with their motive or their opportunity or their intent. It says, after assessing whether there is an acceptable purpose, we can move on. He says that the defendant cannot make certain evidence irrelevant by saying that he will not contest the elements of the defense. All right, so we're going to skip that. Final consideration in the three-step Sullivan analysis is whether the probative value is substantially outweighed by the unfair prejudice. At the third step, the burden shifts to the defendant. If the probative value is closer to or equal to its unfair prejudicial effect, then the evidence must be admitted. So they're saying here under Minnesota law that if those scales are sort of equal, then it should come in. Now let's go through the analysis. All right, so those were the rules. I could have skipped all that. The Kenosha, the court should admit evidence that the defendant assaulted a female. So let's see what's going on here. They're saying he was charged with multiple felonies. The prior acts of violence happened on July 1. They offered to show his intent to cause bodily harm, right? So Kyle Rittenhouse, the prosecutor says, is intending to hurt people. He did so on July 1, which I thought was... Yeah, so they got a typo here, right? June 1 was this date on June 1. And then they say over here that it was July 1. He prior acts of violence. Okay, so somebody, well, Kyle's team can find that, I guess. On that date, the defendant is seen in video footage near the lakefront in Kenosha. The defendant is present with several other people of similar age. In the footage of this group of teenagers, two teenage girls are involved in what appears to be a heated argument, while others of the group are standing by. At first, it appears they're going to break apart, go their separate ways. They begin to fight. The defendant suddenly involves himself in the fight. He grabs one of the two females, punches her back repeatedly with a closed fist. The female teenager is pulled away. Several other individuals then rush towards the defendant to break apart the parties. The video ends shortly thereafter. Okay, so they're talking about what, like a high school fight? Because these are 17-year-old kids. Okay, so they're going to get that admitted. Well done there, Thomas Binger. Good job there, buddy. All right, so the prior act also shows a consistent motive. Yeah, so because he got into a fight with some kids, in both July 1 or June 1, who knows, and the August 25th incident, he willingly and intentionally put himself in violent situations. My God, this guy. In July 1, rather than simply pull apart the parties or contact law enforcement, he begins violently attacking one of the females. I think I've seen that video, and it's basically nothing. So then they're going to take that and try to extend that into illegally arming himself with a dangerous weapon and shooting people. He shot 3 people, 2 people died. Right, so he got into basically a high school fight in July or June, who knows. And it's now a precursor to double homicide. Wow, that's crazy. You ever been in a high school fight before or gotten into an altercation with anybody in high school? Did you suddenly feel the urge to go out there and just start executing people with an assault weapon in the middle of Kenosha? Me either. Never felt that way at all. Not once. The second prong of 904 involves relevancy, right? We're talking about relevancy. Is the evidence relevant? Is that relevant at all? Is the fact that Kyle Rittenhouse got into it with some female at a high school or wherever that was relevant? He's saying, well, yeah, it is. It happened on July 1, which is only 2 months before. He's also an Illinois resident. He came twice, right? He came to Wisconsin in both incidents. He willingly put himself in violent conflicts in both incidents. Then we go back over to the third prong. They shift the burden over to the defendant. So now what they're saying is, they're saying the way this works is the government is asking that this evidence be admitted. So they've got the burden to prove the first two prongs, that it's permissible, that the rules of evidence say, yeah, you can bring that stuff in, and that it's also relevant. Well, it's relevant. It happened recently. He's, a violent guy, whatever. And once they're able to prove both of those things, then the burden to prove the third prong sort of shifts over to the defendant. And then they got to show that if that comes in, it's going to be unfairly prejudicial. The government's going to, so nope, this is too prejudicial, they'll say, and then the government will respond back and say, no, this is why it's more probative and not so prejudicial. So here they're saying that the evidence is not unfairly prejudicial. They say, first, a curative instruction can provide the jury with the framework on how to evaluate the other act's evidence, which is such a crock, right? So they're saying this evidence is really bad. It's relevant, it's permissible, it's probative, so we got to get it in. But when we do get it in, it's so problematic that we have to provide the jury with a curative instruction to correct the problem so that they don't get confused. One of the prejudicial effects that we consider is the tendency to confuse a jury, right? It could be prejudicial for many different reasons, one of which might be to confuse the jury. So the prosecutor here is saying, well, we have to actually, if we do get this in, we're going to have to tell the jury that this is a problem and we have to correct this so that they can apply these new facts fairly and properly. So, or how about you just don't bring it in the first place because it's not relevant. All right. Second, the evidence being sought is of the same nature as the charged conduct, right? Which is such a stretch. It's an assault charge, guys. It's not a shooting double homicide, which is what happened. The evidence is not overly prejudicial. It's highly probative. The state therefore respectfully requests the court admit the evidence. This is just terrible. There's almost no analysis in this paragraph. This is for the third prong of this analysis. The burden shifts. First, a curative instruction. Second, the evidence is of the same nature. Therefore, it's not overly prejudicial. Wow, and it's highly probative. We have two sentences of analysis here. This is really pretty bad. All right, number two. Let's see. The court should admit evidence that the defendant is associated with the Proud Boys organization. So I don't think that the judge is going to let that prior assault come in. I don't think so. Government is making a stretch on this. I think it's actually kind of reprehensible what they're doing there. I think they're trying to just get this out in the public and sort of make a big deal about this. Because I can't imagine why a judge would let that in at all. I'll be shocked if that comes in. We'll see. The court should admit evidence that he's associated with the Proud Boys organization. All right, he says on January 13th, the state filed a motion to modify its release on bond. He went to a bar after he got out with several members of the Proud Boys. On January 5th. The state incorporates that into their motion. Proud Boys are a violently racist organization, blah, blah, blah. Over the past years, Proud Boys have violently attacked everybody. Okay, the state has learned that the people with the defendant included the leader of the Wisconsin Proud Boys organization and several of its highest-ranking members who proceeded to serenade the defendant at the bar with the song from the Broadway musical Aladdin. The defendant posed for pictures, flashing their OK sign. Obviously, the defendant shares their beliefs and has been named an honorary member of the organization. It's, oh my gosh, it's just it's like mind-bogglingly bad. Obviously, the defendant, it's making presumptions where it's not fair to do that. All right, let's see what else. This is really bad. This is hilariously bad. The evidence is relevant and admissible because it goes to the defendant's motive and intent for coming to Kenosha. The defendant claims that he wanted to protect the car source business from rioting, but that claim is highly dubious, they say. The defendant has no previous ties to that business, so what? He did not work there or know The owner, so what? He was not asked directly, anyone associated at the business to be there. Okay. All right. The defendant did not illegally arm himself with a deadly assault rifle and wade into chaotic scene simply to protect a random downtown car lot he'd never heard of before. He did it because he wanted to support a cause that he believed in. The motive for being there that night is a key part of that case. After the shooting of a black man by a white Kenosha police officer on Sunday, many came out to protest to be what they believed to be an injustice. Unfortunately, some individuals took this opportunity to riot and destroy businesses. Yeah, which they're not too upset about, I guess. By the following night, many people had come to Kenosha to counter that protest and what they perceived to be the Black Lives Matter movement behind it. The two opposing sides escalated Tuesday night when the defendant came into town. He was clearly aligned with the counter protesters. So, another reason I think that this is pretty shoddy writing is anytime you see lawyers, use these words a lot, it's easy to use these words clearly. When you say clearly, right? Clearly. And there was another one over here says, obviously, right? Obviously, the defendant shares their beliefs. And when you make claims sort of without analysis, you say the evidence is not overly prejudicial. You say it is highly probative. Okay, well, where's the analysis there? Where's the actual analysis? We're doing the third prong of 904 analysis. Where is it? The evidence is not unfairly prejudicial, but where's the analysis? I know you have to turn that over to the other side, and then you're going to respond to it, right? The burden shifts to them, and then you respond to that. But you're just sort of making these blanket conclusions. Obviously, the defendant shares the beliefs. Not really. Why? Because he was at a bar? You're just sort of you're jumping to conclusions, and it's just sloppy writing. He was clearly aligned with the counter protesters. Okay, like you can make those arguments, but you have to have some evidence to back that up. All right, the defendant's presence, as well as the presence of other armed individuals, made the potential for violence a certainty. No, it did not. Rather than making things more peaceful, the defendant's presence increased unrest and chaos, right? These are all conclusory statements. It is important to remember that only people killed in this saga were killed by the defendant. The only person seriously injured following Jacob Blake's shooting was shot by him. The defendant deliberately aggravated the situation, which are just all conclusions. It's anticipated that he's going to attempt to assert the privilege of self-defense at the trial. Yes, his association with the group is relevant to that assertion. By illegally bringing a weapon to an already volatile situation, they forfeited their right to the self-defense claim. Simply put, he was a clear and present threat. He was the aggressor. After all, that's what happened in the end. It was not the defendant who possessed the right to self-defense that evening. It was everyone else to defend themselves against him. But Kyle Rittenhouse was being chased by the other people. It was not the other way around. Did he watch the video? Much like members of the Proud Boy take pride in violence, the defendant is evidently proud that he killed 2 people and seriously wounded a 3rd. Well, he was being attacked. Hello. He posed for selfies as if he is a celebrity. His family sold merchandise with his images on it. The lack of remorse on the part of the defendant strongly suggests that he was intent to commit violence. That is just wild. It was his intent to commit violence. Do you understand what that sentence is saying? That Kyle went there to go shoot people. We all watched the video. All right. The fact that he has since been celebrated, his notoriety strongly suggests that he set out to achieve the goal of becoming famous. He says that his association with the Proud Boys goes directly to his intent and motive, as well as his claim of self-defense. The court should admit evidence of this fact for the foregoing reasons. All right, so they want to introduce his state of mind. Signed off on by Thomas Binger. All right, so here is that photograph, right? That everybody's freaking out about. 2 signs holding the OK sign up, right? That's in the document. So apparently they want to taint the entire trial with that. So I guess that has something relevant to do. The Proud Boys, if it's a violently racist organization, Kyle Rittenhouse shot white people, right? There were no black people that he shot. Okay. I don't think that comes in either, my friends. This prosecutor is scrambling and reaching because he knows his case is dog doo-doo. It's not any good. And his motion drafting is as bad as his preening in the Zoom hearings that we see very regularly. All right, let's see what else is coming up on the docket. So we have on September 17th, we have at 10 a.m., we have a motion hearing to follow up on all of those different motions. And then on November 11th, we're going to start jury selection in courtroom 209 for Judge Bruce Schroeder. That's the Kyle Rittenhouse case. So we are in the process of requesting the other documents that Kyle's team submitted. I don't have those yet. I'm hopeful that I can get them from the court. I'm not licensed in Wisconsin, and so I'm not sure if they're going to, accommodate us there. But I did submit an email over to the court clerk over there. She seemed very helpful, so we'll see where that goes. When we get those other documents back, we'll be curious to see what else is in there. Of course, there are motions in limine that Kyle's team filed, which are motions that seek to limit some of what can be said during the trial and during jury selection and those things. So it could be some very interesting stuff in there as well. And then we're queued up to see what their expert witnesses have to say. So we're going to go get those documents. If you have them and you want to shoot those over to me, I would appreciate them. Otherwise, we're going to get them if they'll send them to us, and we'll cover those here. Let's take a look at some of those questions that came in from watchingthewatchers.locals.com. Of course, we've got a form over there now, which is linked up where you can ask some questions. Let's see who is here first. Says, Rob, if this was your case, would you place Kyle on the stand to tell his story? Probably not. I don't know. Probably not. First of all, he's a 17-year-old, 18-year-old kid now, right? He's very young. I think the case is pretty clear. But if I don't know enough about the self-defense rules in Kenosha. I need to learn about those more to see how that works and how that interplays, right? It's a good question. I don't know what I would do as this continues to unfold. I'll have a better answer for that. I certainly want to see what the rest of the arguments are from his attorney, but I'm not sure, right? You almost never put the defendant up there. All right, Kyle, another question comes in from Want to Know, says, Kyle had the worst ADA except Trump's New York one, both totally political. Can they both be fired for judicial misconduct? So not for judicial misconduct, but it would be a prosecutorial misconduct if they did something that was egregious enough to reach to that level. But it's a pretty high standard. It has to be something that is sort of like actual malice, like intentional improprieties, more so than you just don't like their charging decisions. You can imagine prosecutors, many people don't like them. They get a lot of the same grief that we get as defense lawyers, just from a different perspective. Good question. Want to Know. Let's see who else is here. We've got Chairman of the Board says, I say with complete sincerity that Kyle's defense team should hire you and use your breakdown video in court. I can't imagine the jury watching it and still convicting. Yeah, I don't. Look, I would love to do whatever I could to help Kyle. I think he's got a pretty good team. I know that he had a bad team for a while now. I know that John Pierce was on the Tim Pool show. I did not watch it because I don't know why he was on there in the first place. I don't know what the heck he knows about anything. John Pierce was somebody that we poked fun at some time ago, right? John Pierce was the guy who wanted to fight Kyle Rittenhouse's extradition from Illinois back over to Wisconsin. And I was screaming back then saying, hey, dummy, why? You can't get him out in Illinois because he's non-bondable there. Send him back to Kenosha, generate the $2 million bond. We'll get the country will fund that immediately. But they kept him in custody for like 2 months. I was screaming about this, saying this was the dumbest thing I've ever seen. And then when John Pierce actually went into court and lost the extradition hearing, the quote that he gave in there was one of the dumbest things I've ever heard. It was like he's in a Tom Cruise movie thinking he's in front of a court of law in Hollywood. He's like, Your Honor, something about this form. And he goes, game, set, and match, Your Honor. That was a quote that I read in an article. I'm going, what? Nobody talks like that in the law, right? They talk about that if you're in Hollywood, but nobody talks like that. And as soon as I started to see some of his antics, I mean, this guy is not a defense lawyer at all. And so he's gone. Apparently he was on Tim Pool's show and for some reason, but I know he's got a better team, some boots on the ground with Mark Richards, seems like a good attorney. Chief Arisi is a good attorney. I know Robert Barnes is working on the case. So he's got, some good people now, which is good, but I would be happy to help because man, this is a very important case for self-defense. Very, very important. And it needs to go right. All right. No pressure. All right. Good to see you. We've got Arnie B5 says, free Kyle USA. is a link from vivabarnes.locals.com. I just mentioned him. Would like to help Kyle. Robert Barnes is loosely associated with the defense of Kyle. Yeah, so free Kyle USA, and go check out vivabarneslaw.locals.com. They are on our Locals platform along with us. Good company. Let's see who else. We've got Speech Unleashed. Says the leader of the Proud Boys being black does not preclude him or the group from being racist. Remember, according to the left, being white is a state of mind, also known as multiracial whiteness. Yes, I forgot about that. Yeah, we talked about the multiracial whiteness here for some time because a lot of people back prior to the 2020 election, they were just scratching their heads wondering, how are all these minorities voting for Donald Trump? This is ridiculous. They're not even racist white people. And then suddenly somebody got the brilliant idea that said, oh yeah, but maybe they're racist non-white people. And then they started to, we're just going to call it multiracial whiteness. So you can be, this is an article in the Washington Post. Go type it into Google, multiracial whiteness. You'll see it all over the place. We're living in bizarro world, my friends. It's no question about it. Osak is here, says, Rob, this question is a little off topic. In Arizona, if you were able to get the case sealed, would that include any docs or evidence used with getting the case sealed also? So it's kind of depends, I guess, on what you're talking about. Yes, if a case is sealed, then all of that's going to be sealed, but you'll still be able to sort of know of its existence. So you won't be able to sort of see what's in it, but you'll be able to see about it. It would include the docs and the evidence. It depends what the judge seals, right? So the judge can seal and unseal certain things. So like in Ghislaine Maxwell's case, the judge is slowly but surely unsealing a bunch of additional documents, sort of piecemeal. And we really don't know what's in it until we get to see what's in it. Let's see. We got Todd Trouts here, said, Robert, is this how this works? George Floyd's prior violent acts were not permissible, but Kyle's are permissible. Right. Exactly right. That's exactly right. Right. And we'll see what happens. I don't think that any of this stuff is coming in. I think this prosecutor is reaching big time, but that's what they do. No Doubt says, Rob, do you have any other insights on this judge from the clips you have seen so far, or have you heard from any other attorneys and how he manages his court? So I actually like this judge so far. His name is Cohen, I think, and is it Cohen? Let's see. Schroeder. Why was I thinking Cohen? It's Schroeder. Yeah, Bruce Schroeder. So I do remember listening to him. He actually scolded Thomas Binger a little bit for using the word victim. He was referencing, I think Grosskreutz was on the call with them. Grosskreutz was, I think, the guy who got his kind of elbow shot off. And he's been very much following along on all of these Zoom proceedings. Remember, he's a victim here, and so he gets to participate. Many states, I don't know Wisconsin specifically, have what are called Victims' Bill of Rights. And so you get to participate and sort of express your displeasure and all of that. So Grosskreutz has been following along for some time. And at some point, Thomas Binger said, Your Honor, we have the victim and his father on the phone. And the judge said, hey, excuse me, we're not using the victim language here, okay? Nobody's been convicted of anything yet. Rittenhouse is entitled to the presumption of innocence. So we're not going to use that term. You can call him Mr. Grosskreutz or whatever, but don't use that term because it's pejorative, right? It's sort of presuming that he was the victim and that Kyle was not self-defense. Now, many other judges don't follow that rule, right? Many judges will just say, yeah, victim's fine. We're gonna use that label. It doesn't mean anything. It's just sort of an identifier. But this judge was very, very careful about that, which is kind of a nice thing from time to time, right? The defense attorneys don't get many of those privileges. Let's see. Want to Know says, do you think YouTube thinks Kyle is guilty? Does you think YouTube thinks Kyle is guilty? Isn't that the only thing that matters? Does YouTube think Kyle is guilty? I don't think so. I think not this channel. I don't think this channel does. That's for sure. I don't, certainly. Let's see. Speech Unleashed is here. Says, maybe the FBI should add, has a group of people saying a Disney song to you as a possible sign of domestic terrorist group trying to recruit. There's a lot of... look. People get violent over like sports games and stuff like that. I mean, how far do you want to take this? All right. Thunder7 says, The prosecutor appears to be very desperate, trying to paint Kyle as a white supremacist domestic terrorist. I don't think it will work. What do you think, Rob? Who is his lawyer now? A bit of confusion on locals. So he's got two lawyers. He's got Mark Richards, who is an attorney out of Kenosha, who does criminal law out of Wisconsin. And then he brought another attorney in, Chief Arisi. And so I think Robert Barnes is sort of, doing some of the public stuff, kind of a public advocacy, and generating some revenue to support the legal fees. But that's my understanding. I could be speaking out of turn, but my understanding, well, per the court docket, the official attorneys who are listed are the two that I mentioned, Mark Richards and Chief Arisi. So they're both, on the formal heading on court motions. And so I think you can rest assured that they're going to be the ones appearing. All right. We also have some other questions. Oh, look who's here. Tree Mendes is in the house. Tree Mendes says, what is the prosecutor talking about? Wasn't the first guy chasing Kyle down because Kyle put out a fire that he had started? Wasn't he going around giving first aid to protesters throughout the night? How is that going out with the intent to harm people? Yeah, it's not. The prosecutor is full of it, and he's trying to, I think, kind of put a poison pill out there into the court of public opinion, which is problematic. Let's see. Says Jeremy Matredas here. Says, Rob, you are great at picking apart and analyzing writing. My favorite book for this is On Writing Well. Unfortunately, there is so much poorly written words these days. Yeah, it is. I'll acknowledge I'm not the best writer in the world. I like to write. I like to read. I like to listen to a lot of language. I think that mastering the English language, some of the best advice I ever got was that. And you know who I got that from? Rush Limbaugh. Honestly, as a kid, that was the first place I heard that, when my mom used to listen to him in the car when I was a young boy. And he used to say all the time, people would always say, Rush, what can I do? I want to be out there doing things. What can I do to help? And he'd say, listen, you got to master the language. You got to learn how to speak it, read it, write it, articulate it, learn the words, and learn how to communicate, because that's how you communicate ideas. And if you can communicate ideas accurately, that's a powerful skill set. And so, I try to be careful with English and practice. That's part of the reason I do this show, candidly, right? Is to get out here and just practice talking off the cuff, stream of consciousness. We'll see where that goes. I think it'll be useful. Let's see what else. We've got Osak says, Rob, why do defendants change their plea to guilty right as a trial starts? It's a good question. It's a very good question. This is a procedural criminal law question. And when you start a criminal case, you are charged with a crime, right? Somebody's making an allegation against you. And so in order to start the process, you have to respond to those allegations. So one of the first things you could do if you wanted to is just say, yeah, I did that. I'm guilty of that. Sure. People do that all the time. Sometimes people call us and they'll say, hey, I just want to get this over with. If I hire you, what's this going to look like? And we say, well, we're going to fight the hell out of it. It's going to be 6 months and file this motion. And we got this expert and we've got this procedure and here's our plan. And they say, I don't want to go through any of that. Can I just go and plead guilty to this thing? And you say, yeah, absolutely you can. And they say, well, what are the penalties for this? And you say, well, it's going to be this and this and this. And they say, well, I can live with that. It doesn't bother me at all. Maybe I've already been to jail, right? Oh, I've had people say 30 days in prison or 30 days in jail. That's it. I'll take it, right? No problem at all. I'm not going to hire a lawyer. What do you charge? Oh, that's too much. Okay, I'll do 30 days, no problem. And you say, okay, great, right? That's a solution for you. But you could change your plea at that moment to guilty. I don't ever advise that, right? Because you don't even know what is in the case. You don't even know what their evidence is yet. So sometimes people do that, though. It's their life. They can, choose to do that. But the normal way you do this is you plead not guilty. You say, oh, you're charging me with a crime? Yeah, didn't do that, not guilty. And remember, in America, the presumption of innocence is still in existence, and the burden of proof is on them. They've got to prove you're guilty. You don't have to acknowledge that or agree to that or acquiesce to that in any way, shape, or form. So you say, you say so? Prove it. All right, go get the evidence, and let me see it all. Motions for discovery and notice of our defenses. We're going to be filing, all of these different motions in limine and suppression, and list goes on. Now, you can go through that process and you can enter a plea of not guilty and fight, and see at the end that, you know what? My shot at trial is not looking so good. Or you work out a benefit with the prosecutor and you say, listen, we've got some pretty good defenses here. They're pretty good. You've got a pretty decent case as well. It's pretty decent, but we're not real sure where this is going to go. So how about this? How about you dismiss the most serious charge. I'll plead down to a lower level offense. We'll compromise on, the jail, the probation, the fines, the fees, the restitution, all of that other stuff. We'll negotiate this thing out. We'll save everybody a trial. You'll get a little bit of a victory. We'll get a significant benefit here on the defense. We'll close the whole thing out. Judge will be happy. We won't have to impanel a jury. What do you say? And sometimes you can negotiate a good deal out. And then at that point, before the trial starts, you enter the change of plea. You change your plea from not guilty to guilty, but guilty to a better charge, right? A reduced charge with, I would say, variables that you have fleshed out and that you know what you're going to be getting, which is oftentimes a better resolution than going to a trial where everything is, kind of up in the air. And a lot of the predetermined penalties that you might be getting under a negotiated plea are no longer available to you, right? You go to trial and you lose, you don't get that deal anymore. Now you're talking about the maximum penalty. And so you can limit your exposure by having a good plea deal. So there are good reasons to do that. Great question. All right. And we got two more. We have one from Feisty Lady is here, says, if Kyle's intent was to shoot and kill people, why did he bring a medical equipment bag with him? In one of the videos, Kyle even stated he was there to help with anyone who was hurt and wounded. Yeah, he did, right? And he wasn't he also on pictures like scraping off graffiti and stuff? Like, is the prosecutor going to talk about that one also or not? Probably not, right? Good question, Feisty Lady. Good to see you. And our last one of the day comes in from Nadarb Lasir. No, we got another one. Nadarb Lasir says, since we cannot rely on the courts to punish the government like this guy, would it be possible for the public to start something similar to a union, but to secure our rights and punish the government instead of jobs for all citizens? So, Nadarb, let me give you a sneak preview on something I'm working on. So I'm working on this presentation called First Principles for Criminal Justice and American Freedom. What are the first principles for justice? If we wanted to just sort of re-envision our entire justice system, what would it look like? And I think the way that we do that is not going through the government, right? It's not by mandating anything or legislating anything, because the government's not going to do that. I think that the biggest problem, the most rational starting point, is to rebuild what I call our informational supply chain, which is going to be in existence for the justice system. So the justice informational supply chain, it's entirely broken. We have no idea what the data says anywhere, right? We have very old numbers from the FBI, 2019 numbers about crime data and statistics. We've got literally thousands of different jurisdictions, right? We have thousands of different police departments. Everybody is kind of doing their own thing. Nobody's really communicating much about anything. And it's very difficult to get good data because it's just not being shared and communicated appropriately. And so it's very difficult for us to actually know where the problems are. I've made this point previously, right? The Biden administration is now saying that all of our problems are based on gun violence. Okay, well, how can you even argue that? Because nobody knows what the data says. Everybody can go out and just say, oh, look at my spreadsheet. It says gun violence. But somebody else can go get another spreadsheet and say it's about something else, because nobody's really talking to each other. And so I've got this vision for how you can create a volunteer. It's blockchain. I know it's blockchain. It's a blockchain methodology for rebuilding the supply chain for criminal justice. So I have this whole thing I'm working on. The point here is this. In order for this to work, you would need enough public pressure to convince people to go in and basically demand that police departments voluntarily participate in this new scheme, right? And the public runs the new scheme. The public runs the new, let's say, framework for justice. And you would voluntarily sort of mandate that local police departments adhere to these new policies. And so you're building sort of a parallel system. Once you get data that's a little bit better, once you can start seeing what these prosecutors do, once you can start knowing what their conviction profile looks like and what types of crimes they prosecute, and you start getting a deeper understanding of who these people really are, these prosecutors, these U.S. attorneys, these judges, people will start to wake up and they'll start to demand a little bit more accountability and transparency. I don't have a solution for the justice system. Do we end qualified immunity? Do we mandate body cameras? There's a lot of different solutions. The bigger problem, the first problem, the way that we restructure this from first principles is based on better information, better data. A lot of privacy concerns, of course, right? We don't want sort of centralized amalgamations of data, but we do want distributed sort of good data, real data, because then we can really start reforming our society. And so I've got a vision for how this works, and I'm talking about sort of interfacing in different ways, and I got a whole outline. But I like what you're talking about, right? The idea here is the government is way too corrupt to fix itself. You're never going to find a district attorney's office or a state bar or a judicial enterprise that's like, oh yeah, we're going to start, we have a lot of problems here and we're just going to reform the system. No, it's not going to work. I know that because I'm working in the system right now. I've been doing it for some time, and it can be very, very futile feeling. So I write about this in my book. We need a sort of we need a multi-pronged approach. We need people in the system working to reform the system, and we need a lot of demand and public pressure outside of the system to reform the system. This is why I was excited when we started to see some calls for reform back during last year in the summer of unrest that evaporated immediately when this whole thing turned into, race, basically race wars, and had nothing to do with justice at all. And beyond race, it had to do with removing Donald Trump, really, I think was the primary purpose. So I got a lot to say about that. I think it's probably going to be the better portion of maybe my life's work. I don't know. We'll see. All right. We've got chairman of the board says, when someone pleads guilty because of a deal, how do they honestly answer the question about whether they offered them anything in trade for their plea? That's a good question. So when you're going through the plea synopsis there, one of the things that the judge will ask you is, has anybody promised you anything not contained in this plea deal? Right. So the judge will hold the plea up. Hey, did you sign this? Okay, I'll read through it, make sure you understand everything. Did anybody promise you anything not contained in this document? Like, did anybody say, if you sign this, I'm going to give you $1 million, or I'm going to make sure that you get a new car, or we're going to pay your mortgage for a month? Anybody promise you anything? No. That's what people will typically say. The judge is not meaning something like, did you get a reduced plea deal? That's not what they're asking about. They're asking for other external influences. But it's a good question. It's a little bit of a nuanced question there, but good one. Good to see you. We have Osak, last one. Osak says, sorry, Rob. I meant to say when the trial, like open statement starts, then change the plea. Well, so that happens less frequently, Osak. So, sometimes that happens. Once the trial starts and the jury has been impaneled and you have opening arguments, typically the trials will continue forward until you have a conclusion, a verdict. Occasionally what will happen will be something happens and maybe you have sort of a last minute plea deal. This doesn't happen frequently, but sometimes that might happen. If there is some sort of a situation where the government's witness doesn't show up and they say, man, we're not going to get that first charge. We'll give you a smoking plea deal, but you got to take it like now. Sometimes you can get those last minute deals. And that, my friends, is it from the questions. All of those came over from watchingthewatchers.locals.com. And of course, I want to welcome our tremendous new members who signed up over there at watchingthewatchers.locals.com. We've got you, Ramirez. Welcome, you, Ramirez, signed up. We've got Angela B66. Welcome to Angela B66. Welcome to the community. We've got Freedom Lives is now here in the house. And my friends, we have one Florida man, which I think is our second Florida man. So this is about to get wild up in this show. We've got 2 Florida men here. Oh my goodness. It's going to be total madness. By the way, if you want to sign up over there at watchingthewatchers.locals.com, which is where we're chatting right now, it says you can join now by going over to that address. Of course, it's $5 a month or $50 annually. We extra love you when there's a yearly sign up. Very much appreciate that. We've got some good stuff that's happening over there. I just posted a little bit of an update. You're going to see some other types of content created from our social media profiles and things. So go check that out if you want to take a look. But the real reason to be there is to connect with people. And we've got a pretty awesome event coming up in July 24, 2021. We have our monthly locals meetup via Zoom. And so you can come swing by, have your cameras off, on or off, whatever you want to do. It's a lot of fun. We had about 35 to 40 people in the last 2. And so it's just a good time to kind of put names to faces and ask some questions. We've heard from people in other professions and other parts of the world, and we're trying to sort of build a little bit of a community, something one brick at a time that gives us a little bit of a place of respite from some of the other big tech platforms. And we would love your support over there at watchingthewatchers.locals.com. And that, my friends, is it from me for the day. I want to thank you so much for tuning in with us. We are going to be back here same time, same place tomorrow, same location, same time. It's going to be at 4 p.m. Arizona time, 5 p.m. Mountain, 6 p.m. Central, 7 p.m. on the East Coast. And for that one Florida man, 2 Florida men now, everybody else, have a tremendous evening. Sleep very well. I'll see you right back here tomorrow. Bye-bye.